Hi, my name is Gordon Weichel and I'm a litigation attorney with Venn Law Group. I'm going to talk to you about the enforcement of non-compete and confidentiality clauses in employment agreements. Now, as an employer, there are plenty of good reasons to want to keep your employees from taking their experience and knowledge to a competitor. While there are legal limitations on your ability to do so, some ways that you can limit your losses are non-compete clauses, at least for the time being, non-solicitation agreements, and confidentiality agreements. Now, there are whole books on how to draft a valid employment restriction, but I'm going to talk in this video about how to enforce a valid restriction. The first step is to determine what your specific contract prohibits employees from doing when they leave. Generally, a restriction has to serve a legitimate business purpose, which means it cannot stop mere competition, but it can protect against the theft of intellectual property, trade secrets and confidential information, or protect a relationship built between a business and its customers. This means when an employee leaves your business to do the same or similar work in the same industry, in the same location your business covers, or with your business's existing clients, they may be violating their restriction. The second step is to look at the harm you're suffering or will suffer as a result of the violation. If current customers are leaving or threatening to leave for the employee's new company, current employees are being poached, or your business is missing out on market opportunities such as losing job bids to the new company, your damages may include irreparable harm, which is a legal term of art meaning that no monetary award will make you whole. The third step is taking action to enforce this restriction. This can take two forms, injunctive relief and payment of damages. An injunction is a court order barring the employee from engaging in specific conduct. These orders include a temporary restraining order, which lasts 10 days, a preliminary injunction, which lasts until a trial, and a permanent injunction, which will bar the conduct for the amount of time set forth in the contract. Each of these orders requires a trip to court and will incur significant costs, and your business has to decide if those costs exceed the harm being caused by the violation. To recover monetary damages from the employee, you will need to show the economic harm your business suffered as a direct result of the employee's violation at a trial. This is the stage where you will have to show the damages from lost contracts, lost profits, and lost opportunities. The trial is also where you may be able to get an injunction lasting the remaining time period of the restriction, and where you will have to show that you will be unfairly harmed by any violation of the restriction for the duration of that time period. At every stage of the enforcement of an employment restriction, you will need to show a legitimate business purpose for the restriction, that the restriction served that purpose and that purpose alone, and that an employee violating the restriction unfairly harmed your business. If you want to stop the violation with a court order, you will also have to show that the harm cannot be fixed by monetary damages alone. Enforcement of an employment restriction may not be cheap or easy, but it can be an essential tool in protecting your business against unfair competition, if undertaken with the appropriate preparation and guidance. At Venn Law Group, our attorneys are experienced in the drafting and enforcement of employment restrictions and can help your business determine if one is right for you and ensure that it is enforced to protect your business. To learn more about how we can help, visit our website at venlawgroup.com.